They found the receipt. Not a rumor, not a tweet, not some blogger guessing from their basement. A legal receipt, filed in federal court. And when the smartest legal minds in America read it, they didn't just shake their heads, they picked up a pen and buried him with it. This is the part of the story nobody was supposed to see. What just happened to Drake in the Second Circuit Court of Appeals isn't just embarrassing, it's the kind of thing that rewrites how people remember you. And the worst part, he asked for every single second of it. But before I lay this whole thing out, and trust me, by the end of this, you're going to understand exactly why the walls are closing in with no escape hatch left, I need you to do something. If you care about hip-hop, if you care about the culture, if you care about truth being told the right way, hit that like button, subscribe, and turn on notifications, because what we're about to go through right now is something that will be referenced for years. This isn't just another Drake update. This is the autopsy. Let's go. I want to set something up before we get into the heaviest part of this, because context matters, and I refuse to let anyone say this is being blown out of proportion. What I'm about to walk you through is the moment where the legal system, the academic world, and the entire hip-hop community simultaneously looked at one man and said the exact same thing. You did this to yourself. On April 3rd, 2026, something happened that I genuinely do not think Drake or his legal team were remotely prepared for. The Floyd Abrams Institute for Freedom of Expression at Yale Law School officially entered the fight. Not with a tweet, not with an opinion piece, not with some vague statement of concern. They filed a full amicus brief in the Second Circuit Court of Appeals, and they filed it directly against Drake. Let me say that one more time so it sits right in your chest. Yale Law School, home to some of the most respected legal scholars walking this planet, looked at Drake's entire case, read every single page of his 117-page appeal, analyzed every argument his lawyers crafted, and said, no, we need to step in and make sure this goes no further. And if you think that's bad, hold on, because that was just the first brief. The same exact day, a second amicus brief dropped. This one came from social scientists and legal scholars at Howard University, Tulane University, Virginia Polytechnic Institute, the University of Richmond, and several other institutions. Represented by the UCI Intellectual Property, Arts, and Technology Clinic at UC Irvine, these aren't random people with opinions on the internet. These are researchers who have spent decades, their entire careers, studying exactly this intersection of art, race, law, and free expression. They looked at everything Drake filed and essentially said, he's not just wrong, he's a threat to the entire culture. Now here's where I need you to stay locked in, because the details of what these scholars actually wrote in these filings are so devastating, so precise, and so surgically targeted that once you hear them, you will never look at this lawsuit the same way. Not today, not ever. Let's start with the Yale brief, because honestly, this one alone should have ended the entire conversation before it started. The lead scholar on this filing is Professor Larissa Lidsky. If you don't know who she is, let me give you the picture real quick because this matters. She holds the Raymond and Miriam Ehrlich Chair in U.S. Constitutional Law at the University of Florida's Levin College of Law. She is considered one of the foremost defamation scholars in the entire country. Her published work on free speech and defamation is what judges cite when they're making rulings at the highest levels of the American legal system. Her name carries weight that most practicing attorneys will never come close to touching in their entire professional lives. And she read Drake's appeal and essentially said, this man has no case, and here is the exact legal framework explaining why. The central argument of the Yale brief is built around one single word: consent. And when you hear how they applied it to this situation, you will understand immediately why Drake's legal team should be panicking right now. Here's what happened. Go back to April 19th, 2024. Drake drops a track called Tailor-Made Freestyle. On that track, he does something that at the time felt like a power move, like a flex. He taunts Kendrick Lamar directly. He's calling him out. He's daring him to respond. And in the actual lyrics, he specifically, and I mean explicitly, encourages Kendrick to talk about him liking young girls. He wanted Kendrick to go there. He was trying to bait him into it. He was attempting to play that 8 Mile strategy where you bring up the worst accusations about yourself first so your opponent can't weaponize them against you. But here's the problem. And this is where Kendrick Lamar proved once again why he is operating on a completely different intellectual and artistic level than everyone else in this game. Kendrick didn't flinch, he didn't panic, he didn't rush out a sloppy response. He waited, he calculated, and on May 4th, 2024, just 15 days later, he released Not Like Us and did exactly what Drake asked him to do. He used the angle. He called him a certified pedophile. He delivered it with surgical precision, with bars that cut deep, with the kind of lyrical devastation that only Kendrick Lamar is capable of delivering on this earth. And the entire world watched, and the entire world cheered. Now pay close attention to this next part, because this is the legal kill shot that Drake cannot recover from.
The Yale scholars argue that under established New York law, consent is an absolute defense against any claim of defamation, not a partial defense, not a maybe we can argue around it defense. Absolute. That means if you can demonstrate that the person consented to the statements being made about them, the case is finished. There is no legal path forward. Zero. And Drake, on a recorded track, released publicly to millions of listeners worldwide, literally told Kendrick Lamar to say these exact things about him. But it gets worse, because Drake didn't just invite the attack, he acknowledged it afterward. On The Heart Part 6, Drake said, and I am quoting him directly from his own recorded lyrics, "This Epstein angle was the thing I expected." He admitted on his own song that he anticipated exactly what Kendrick would say. He knew it was coming because he engineered it, he baited it out. And then, after Kendrick delivered the knockout blow, after the world watched him get completely dismantled bar for bar, line for line, Drake walked into a federal courthouse and had the audacity to try to sue his way out of it. Let me tell you about the analogy the Yale brief used, because this is going to follow Drake for the rest of his natural life. They compared him to a self-assured boxer who goes completely out of his way to challenge a reigning world champion to a high-stakes prize fight on pay-per-view. The champion accepts, they step into the ring under the bright lights, the challenger gets his head absolutely cracked on live television while the entire world watches from their couches. The referee counts him out flat on the canvas, and then, instead of accepting the loss with any shred of dignity, the boxer limps to a courthouse and tries to sue the champion for battery because he didn't enjoy how those punches felt against his face. That analogy is not mine, that is from Yale Law School, written by some of the most brilliant legal minds alive, filed in a federal appeals court against Aubrey Drake Graham. Let that marinate. And I need you to feel the magnitude of this. This isn't Twitter beef that dissolves in a news cycle. This is a federal appeals court proceeding. These are legal filings that will be preserved in the public record for all of American legal history. When law students study defamation 20 years from now, there's a real chance they'll read about a rapper who tried to sue another rapper for winning a battle, and the country's top legal institutions had to explain to a federal panel why that's absurd. Kendrick Lamar didn't just win a rap battle, he won the legal battle before it even began. He won it the moment Drake opened his mouth on Tailor-Made Freestyle and handed him the entire blueprint on a silver platter. Every single bar Kendrick delivered on Not Like Us was a direct response to an explicit invitation that Drake himself issued publicly, and the Yale brief makes that point with absolute clarity. But we are not done, not even close, because while the Yale brief is devastating all on its own, the second brief, the one filed by scholars from Howard University, Tulane, Virginia Tech, and the other institutions, hit Drake from an angle that exposes something far darker about his true intentions. Now this is where I need your undivided attention, because what I'm about to tell you reveals a level of hypocrisy so extreme, so shameless, that it should permanently disqualify Drake from ever claiming he cares about hip-hop culture again. The scholars from Howard and Tulane built a different argument. Their brief focused on the fundamental nature of rap diss tracks as a form of expression. They argued, supported by 3 full decades of rigorous academic research, that rap diss tracks are a recognized form of artistic expression. They are not factual statements, they are hyperbole, they are competition, they are performance art, and they have been a core part of hip-hop culture since the genre's very inception in the Bronx. But here's the part that should make every single person who loves this culture absolutely furious. These scholars pointed out that Drake himself, not very long ago, was one of the loudest and most prominent voices supporting a campaign called Protect Black Art. You remember that movement? That campaign was created specifically to stop prosecutors from using rap lyrics as evidence in criminal trials against black artists. The entire culture rallied behind it with overwhelming support. Artists signed open letters. Advocacy groups pushed for new legislation in multiple states. The argument was simple, and it was absolutely correct. Rap lyrics are art, not literal confessions. You cannot pull a verse from a song and present it to a jury as proof that someone committed a crime. The words exist within a creative framework. They are protected expression. Drake signed on to that campaign. Drake publicly endorsed that message. Drake put his name and his platform behind it. And now that he's the one who got publicly embarrassed, now that Kendrick Lamar used his God-given pen to expose him in front of every human being on this planet with an internet connection, now Drake wants to do the exact opposite of what he preached. He wants a federal court to treat Kendrick's lyrics as literal factual claims. He wants judges to look at a diss track, a competitive rap record, and declare that these bars constitute factual allegations of criminal conduct. He wants the legal system to do the exact thing he stood on stages and told the world it should never, ever do. All because his pride couldn't survive a loss. The Howard and Tulane scholars called this out with precision. They wrote, and I am pulling this language directly from the filed brief, that though Drake has previously acknowledged this danger publicly, he now paradoxically and problematically embraces it. In plain language, they are calling him a fraud to his face in a federal courtroom. He championed protecting black art when that protection served his interests. The instant it stopped benefiting him personally, he abandoned the entire movement and weaponized the very system he warned everyone about.
And here is why this extends far beyond Drake's bruised ego. The scholars cited extensive research demonstrating that when identical lyrics are labeled as rap music, they are consistently interpreted by listeners and by jurors as more literal and more threatening than the exact same words presented under any other genre label. That is documented racial bias operating inside the legal system, peer-reviewed, replicated across 3 decades of independent studies, and Drake is actively trying to exploit that bias to win a civil lawsuit. Think about what that means for a moment, and let it truly sink in. Drake isn't just suing Kendrick Lamar's label. He is asking a federal court to establish a legal precedent that would transform every single rap lyric in existence into a potential lawsuit waiting to happen. Every punchline becomes evidence. Every metaphor becomes a claim. Every battle bar becomes a liability. If Drake wins this appeal, any rapper anywhere who writes a diss track could be dragged into federal court by their opponent and forced to defend their art as though it were sworn testimony. Labels would immediately stop clearing aggressive records. Artists would begin censoring themselves before they even step into the booth. The entire competitive engine that has powered hip-hop since its birth would grind to a complete and permanent halt. All of it. Every single consequence, because one man couldn't handle a loss. That is precisely what these scholars told the federal court. Drake is willing to set fire to the entire genre of hip-hop to soothe his own wounded ego. And these are not anonymous Twitter accounts making this argument. These are tenured professors from Howard University, one of the most historically significant institutions for Black intellectual advancement in America. These are career researchers from Tulane and Virginia Tech who've dedicated their lives to studying race, art, and law. And they are all telling the court the same thing. This case is not merely wrong, it is dangerous. Now, let me walk you through the complete timeline, because the walls are closing in and Drake's window is narrowing to nothing. Drake filed his defamation lawsuit against UMG in January 2025, accusing the label of using deceptive business practices to promote Not Like Us, including allegations of radio payola and artificially inflated streaming numbers through bot farms. In October 2025, U.S. District Judge Jeanette Vargas dismissed the entire case outright. She ruled that the lyrics in Not Like Us constitute opinions protected by the First Amendment, and that any reasonable listener would understand diss track lyrics as hyperbole and competitive wordplay, not factual accusations of criminal conduct. Drake's team refused to accept the loss. In January 2026, they filed a massive 117-page appeal in the Second Circuit Court of Appeals. They argued the lower court's reasoning created what they called a dangerous categorical rule that would allow genuinely defamatory statements to be shielded simply because they appear in a rap song. They zeroed in on the phrase certified pedophile, arguing it carries a specific and provable meaning, making it a factual claim rather than artistic exaggeration.
On March 27, 2026, UMG fired back with an 83-page response brief that was absolutely devastating. The label called Drake's arguments astoundingly hypocritical and accused him of attempting to turn the law upside down. UMG pointed out that Drake felt perfectly comfortable using their platform to attack Kendrick Lamar in equally harsh, equally aggressive terms when it benefited his position. He only started crying about defamation when he found himself on the receiving end. Then, on April 3rd, the two amicus briefs from Yale and the Howard-Tulane coalition landed, and the landscape shifted entirely. This was no longer just UMG defending a corporate position. The entire legal and academic establishment of the United States was now actively telling the court that Drake is wrong. Drake's legal team has until April 17, 2026 to file their final reply brief. After that submission, the court may schedule oral arguments where attorneys from both sides present their positions before a panel of judges. If no hearing is ordered, the panel will review all written submissions and issue a binding decision.
Here is what everyone watching this needs to understand about where this is inevitably headed. The consent defense from the Yale brief alone has the power to kill this appeal stone dead. Under New York law, if the appellate court agrees that Drake effectively consented to the statements by explicitly inviting them, there is no legal maneuver, no clever argument, no procedural trick that saves him. You cannot circumvent an absolute defense. Drake told Kendrick to say it. Kendrick said it. The legal analysis ends right there. Even if the court somehow navigates past consent, they still confront the evidence from Howard and Tulane proving that treating rap lyrics as factual statements introduces racial bias into judicial proceedings. They confront the original judge's well-reasoned ruling that these are constitutionally protected opinions. And they confront UMG's 83 pages methodically explaining why Drake's arguments are, in their precise legal terminology, illogical. Every single entity that has weighed in on this case has reached the identical conclusion. The original trial judge, UMG Recordings, Yale Law School, Howard University, Tulane University, Virginia Tech, the University of Richmond, UC Irvine's IP clinic, every single one. Drake is wrong. That kind of unanimity is extraordinary and almost unheard of. It is genuinely rare for this many elite institutions to file amicus briefs in a music-related civil dispute. These scholars and professors don't involve themselves for entertainment. They intervened because they believe this case poses a real and present threat to foundational legal principles that extend far beyond the hip-hop industry. And here is the contrast that makes this entire saga truly devastating for Drake's legacy. While he has spent the past 18 months cycling through courtrooms, filing motions, paying attorneys hundreds of dollars an hour, and trying desperately to erase the cultural damage that Kendrick inflicted upon him, Kendrick Lamar has been doing what generational artists do. He has been creating, performing, elevating. He headlined the Super Bowl halftime show. His album GNX dominated the charts and the conversation. Not Like Us won multiple Grammy Awards. He has been on top of the world, present in the moment, making music that matters, connecting with millions of fans who see him for exactly what he is, the voice of a generation. Kendrick moved on. The culture moved on. The only person still trapped in 2024, still reliving that loss every single day, is Drake. That contrast communicates everything, because winning a rap battle isn't only about who delivered superior bars, although Kendrick clearly did that too. It's about what you do in the aftermath. It's about whether you evolve or whether you let it consume you from the inside out. Kendrick evolved. He ascended. He solidified his position as the undisputed king. Drake diminished. He retreated into courtrooms and legal briefs and 117-page appeals that the most brilliant minds in America now reference as a textbook example of what desperation looks like in print. Consider what a Drake victory, however unlikely, would mean for the genre. Every label would be forced to route diss tracks through extensive legal review before release. Every artist would need to calculate whether a punchline might trigger litigation.
Think about every legendary diss track in the history of recorded music. Tupac's Hit 'Em Up, Jay-Z's Takeover, Nas's Ether, Ice Cube's No Vaseline. Under the legal theory Drake is advancing, every single one of those iconic records could constitute defamation. Records like those could never be made again. The Yale brief specifically urged the court to establish what they call a presumption of art for the entire music industry. This would mean rap lyrics are legally presumed to be artistic expression rather than factual assertions, unless overwhelming evidence proves otherwise. If adopted, this standard wouldn't just defeat Drake's appeal, it would create a permanent legal shield protecting every rapper, every songwriter, every competitive voice in the culture.
Kendrick's victory here would not be merely personal. It will be cultural, legal, and genuinely historic. Kendrick never filed a lawsuit over a diss track, never ran to a courthouse because someone attacked him in a song. When Drake came at him, Kendrick responded exactly the way a true hip-hop artist is supposed to respond. He picked up a pen, he wrote bars, he stepped into the studio, he created one of the most devastating diss records the world has ever heard. And then, he let the music speak. That is hip-hop. That is the tradition handed down from generation to generation. You handle conflict with your art, you compete on the mic, you win or you lose, and then you push forward. Drake chose the courtroom over the studio, lawyers over lyrics, motions over music. And Kendrick, without uttering a single public word about the lawsuit, without filing one countermotion, without even acknowledging the legal proceedings exist, has already won the aftermath as completely as he won the battle itself. Yale said it, Howard said it, Tulane said it, the judge said it, UMG said it, the culture said it, history will say it. Kendrick Lamar won, and Drake asked for every single second of it. April 17th is approaching fast. That's when Drake's legal team files their final reply to everything you just heard. After that, this either goes to oral arguments or straight to a panel of judges for a final ruling. Whatever unfolds next, I will be right here, breaking every detail down for you. If this opened your eyes, hit that like button. Subscribe if you haven't already. Drop a comment telling me what you think Drake's next move should be, because at this point, I genuinely do not believe he has one left. Share this with anyone who still thinks this lawsuit carries merit, because after everything laid out today, there are no more excuses left to make. The smartest legal minds in the United States of America have spoken. The culture has spoken. And Kendrick Lamar, as always, let his music do the talking. This is not just the conclusion of a lawsuit. This is the conclusion of a false narrative that Drake spent years constructing. And the person who dismantled it piece by piece did not need a team of lawyers to do it. He just needed a pen. Stay locked in. Protect hip-hop culture at all costs. Because what we witnessed here is not simply about two rappers settling a score. It is about the very soul of this entire genre. And right now, that soul is winning.